The Uganda National Identification and Registration Authority has dismissed concerns raised by the civil society organizations and legal experts regarding the safety and transparency of its data handling practices during the ongoing nationwide mass registration and renewal exercise. Speaking at the weekly press briefing, several civil society representatives criticized the flawed national ID system, warning that NIRA's centralized data architecture exposes millions of Ugandans to privacy violations and potential cyber threats.
It has this vast amount of data that it is storing, but we as Ugandans, as civil society, we have been questioning the risk implications, and we would think that such kind of information would be out there through their data impact assessment, if they've ever carried out any. And I know that there is an ongoing mass enrollment and mass renewal, and then introduction of new technologies or features on the national ID. We would expect that NIRA should be coming up and publishing a document like that, so that you Ugandans get to know the amount of data that they have, the risks that they anticipate, and the mitigation measures that they have taken to make sure that your data, my data, is safe.
Mohindo emphasized that transparency and accountability are not optional, noting that NIRA has never publicly released a data protection impact assessment, despite maintaining a massive centralized database containing the personal records of over 27 million people. Baker, the acting director of the Uganda Personal Data Protection Office, the body responsible for regulating data collected by NIRA, confirmed that the data protection impact assessment was conducted in March 2024. However, he stated that only summary findings, not the full report, would be published to avoid revealing potential system vulnerabilities.
PDPO, we've had a unique opportunity. I'll call it unique because we've worked with NIRA with this journey of ensuring that data protection and privacy is actually observed. There are a number of drives that may go on and privacy comes as an afterthought, but as the regulator, we can tell you with NIRA, they reached out, we've been working together to ensure data protection is embedded by design and default. So even before the renewal, the mass renewal exercise was rolled out last year in March 2024, the executive director of NIRA invited PDPO at a staff retreat. Though ED, I don't know whether that I can call it a retreat. It was, sorry Brenda, a boot camp, that's the right word. So we were invited, and there were over 400 permanent staff of NIRA in attendance. We took them through the data protection and privacy law, the requirements, and even penalties. Now, this law has penalties. Not just, I'll start with the entity. Any entity, even including government, that misuses personal data can be fined up to 2% of its gross annual turnover. For government, that would mean your budget.
The NIRA Executive Director, Rosemary Kisimbo, firmly defended the authority's mandate, stating that its collection of detailed personal data, including the tribal, parental, and biometric information, is rooted in the Constitution and the Registration of the Persons Act. Also dismissed claims that NIRA was violating privacy or excluding people, stating that the authority only shares data with the third parties upon consent, that even the relatives are denied access without proper authorizations.
By any name arose, we did a impact assessment. What we did not do is name it a digital privacy impact assessment. But there are several measures and features that we measured. We even sent questionnaires to over 100 entities in and outside this country. And you can come for that evidence. Actually, that one was, the evidence was led by a lawyer, John Toa Bahemka. He can give it to you.